Appeal, Rolle Family and Company, Rolle.
Yes.
My Lords, I appear with my learned friend Mr. Andrew Brown on this appeal from the Commonwealth of the Bahamas for the appellant company, Rolle Family and Company Limited. We're instructed by Alan Taylor and my learned friend Mr. Mould appears for the respondent Ina Louise Rolle, and he's instructed by Harcus Sinclair. My Lords, I'm sure you've had a good opportunity to see the material before you.
Yes.
As it were, the first issue I have to deal with is a somewhat procedural one of whether I can take the Section 22 Companies Act point from at all on the basis that
this is not just the trust argument which you've admittedly just thought of, but the whole point.
The Section 22 point, we'll leave that trust argument if I have time to get to it at the end,
yes.
Perhaps, my Lord. The Section 22 point wasn't taken in the Court of Appeal. It was argued fully at first instance, and as a result, my learned friend has indicated perfectly fairly that he doesn't see any difficulty with dealing with it today. Okay. I think, though, that I do need permission to take it. I said in my skeleton argument, my case, that...
Yes, you have that.
Yeah.
I'm grateful. I don't think you need to press the point if it's not contested.
I'm very grateful. In that case, what I propose to do is start with the escrow point, simply because really that was the case that was decided against my client in the Court of Appeal.
Which is your best point?
Which is my best point. That's traditionally we say we leave that to the court to decide at the end of the case. I'm certainly fond of the escrow point, but it is trumped. It is fair to say it is trumped by the pre-incorporation contract point. Because if it is a pre-incorporation contract point, then the statute applies, and we don't deal with the escrow.
So you say on your second submission you don't need to get to escrow?
Yes.
Yeah.
The Court of Appeal in the Bahamas decided it against my clients on the basis of relation back. And you've seen my submission on that. Simply that they got the relation back point wrong. The concept of relation back in relation to escrows is a principle which enables a deed to be upheld. It enables a deed to be held valid. In the Latin used by Lord Cross in the security trust case, it's ut res magis valeat quam pereat. What the Bahamas Court of Appeal have done is ut res magis pereat quam valeat. They've stood it on its head. So that is, as it were, the beginning and the end of that point.
Well, the real issue, I would have thought, under escrow was whether you can demonstrate the necessary intention.
Absolutely right. Absolutely right. And that, on that point, the authorities have been clear for a couple of hundred years that you don't have to actually say, the obvious thing is to say, I'm delivering this as an escrow. But it's been clear for a long time that you do not have to say that.
Yes, it can be implied.
It can be inferred. Exactly, it can be implied.
But I mean, the difficulty here surely is that apart from the terms of the deed and the fact that it was actually delivered before the company was incorporated, there's nothing, or it might be said that there's nothing from which you can imply such an intention. We don't know whether the problem was present to the donor's mind.
No, we don't.
And even if we did, can you imply something on the basis that if the problem had been known to exist, reasonable parties would have agreed to resolve it in this particular way?
It's an implication and an inference that one draws from all the circumstances.
But does it not have to be an inference of actual intention?
Mm.
If one is, in my submission, if one is drawing the inference from all the circumstances, all the facts that were in existence at the time, that is not a process of trying to decide what the intention of the parties were. It's true to say if the parties expressed an intention and had an intention, then that would itself be enough to give it an escrow condition. But if what one is doing is implying from the circumstances and the facts, then as with the analogy of an implied term in contract law, what one is doing is not trying to decide what the actual intention was, because it may well not have been present in anybody's mind at all. One is trying to decide what, not even these hypothetical, what even the hypothetical intention of these people would be, but what the reasonable intention would be of...
But the context that you're referring to there is one in which one is construing language and deciding objectively what it means, irrespective of what the parties may have intended it to mean. But here, we're not construing language, we're endeavouring to import a condition inconsistent with the parties' acts and words, because it would have been a good idea if they had been conscious of the problem. That's a slightly different thing, isn't it?
My Lord, what you have described there are slightly different things, I accept that. But when one's implying a term into a contract, although I accept there is a healthy debate about whether you are construing the words of the contract, the language of the contract, as you've just described, the reality is that if that implied term is not in the contract, if those words are not there, and you're having, as a matter of implication, to insert them, you're inserting them because that's the proper way to construe the contract, but not because the words are in there and you're looking at the language of the contract itself, because the language, by its very nature, is not there.
Does the argument necessarily involve implying an alternative intent? In other words, I want this deed to take effect immediately, but only if it can't do I have some alternative intent.
The way I'd put it in my submission would be that one is, the intention is that it should take effect immediately if it can, yes.
The intention, you would have to say, is that it should take effect as soon as possible.
Yes.
And therefore the fact that he didn't realise how soon that would be is irrelevant. I mean, that has to be the argument, doesn't it?
Yes. As I said, immediately, if that is possible, which implies an alternative, as soon as ever it is possible, yes. And on the facts of this case, in my submission, that is a relatively easy inference to draw, because it is all part and parcel of one process, one transaction. The company is being incorporated, instructions given to the same lawyer a couple of days earlier. According to the evidence, father and son are both going to be the shareholders of this company. The assets are to be transferred to that company. And the natural inference is that he wants it to get to that company.
Not difficult to infer an intention that the grantor wanted the conveyance to take effect. That's easy enough.
Yes.
But have I got it wrong? For the purposes of the escrow, you have to infer an intention, don't you, that it shouldn't take effect immediately. The two alternative intentions are mutually inconsistent, aren't they?
Well, you have to infer that it shouldn't take effect immediately. If the implication is that it should take effect as soon as possible,
I see.
then it's, so to speak, self-executing.
The intention is to take effect.
Is that a point in his favour, or
Well,
probably is?
never mind whose favour it's
No,
in.
it doesn't matter.
I-
It does matter of understanding.
Equally
it.
true
That thought
or
went through my
false
mind, but I didn't feel I could ask that question. The intention is to transfer to this company.
Yeah.
No doubt about that. He wants to do it now because of a mistake or misunderstanding, or maybe, who knows? If we knew that his lawyer said, just do it now, it'll all work out. But we don't know that. He wants to transfer it to that company. He wants that company to get it. There must be an underlying implication that it's dependent on that company having been formed as part of the very process.
But is it? Because if if this is taking place in an environment which is governed by the Act, that's not a necessary implication, is it? Because assuming all the other points in your favour,
Yep.
namely that that the deed of this kind is a contract, and no doubt you'll come to those in due course,
Yes.
you don't need to treat it as an escrow to give effect to it, because it has immediate effect in conferring benefits and burdens on Paul,
Yes.
and on the assumption implicit in the Act that the company, once incorporated, will do what's necessary to adopt it within a reasonable time.
Yes.
That's the solution, and
Yes.
none of that requires the implication of an escrow.
No.
I accept that this type of implication is from conduct rather than from the deed itself, because an escrow almost never tells you it's an escrow in the deed. But nonetheless, the concept that it ought to be necessary or essential to make it work must underlie the toolkit which decides whether or not you imply or infer an escrow, doesn't it?
Well, you're absolutely right. And I was hoping to have a little bit more time to develop my argument on escrow before we came to that point, because that point essentially makes the escrow seem like a sterile argument.
Can I just ask you, the example you give of Mr. Justice Morgan's case, paragraph 13 of your
Yes.
case, the Bank of Scotland, where you've got a deed which is delivered, but it operates implicitly as an escrow until the money is paid. What would the position be if the deed is delivered on the mistaken assumption that the money has been paid? Does it then still operate as an escrow until it is in fact paid?
Well,
I mean, that would be a sort of parallel with our case, wouldn't it?
I'm very, very, very grateful, because that was one of the arguments I was proposing to try and deploy. But it would, because what one's looking at is one is delivering a deed expecting to be paid. One may even believe one has been paid, but the money may not have come through to the solicitor's office. And if one applies as with the analogy of the implied contract, the officious bystander asking the question gets a testy response. Commercial efficacy, commercial and practical coherence, whatever the test is, undoubtedly responds, no, the delivery is conditional upon the money being paid. And if one's making assumptions it's been paid, but it hasn't, if one's ignorant of the fact that it hasn't been paid, it doesn't undermine that underlying truth about the escrow. Absolutely. So, those are my submissions on escrow. That it is an objective test. It's a question of looking at the facts and the circumstances to see whether one properly infers that the intention is that it should be completed conditionally upon the company being in existence, and that by analogy to implied terms and so on, that's
I mean, the delivery to Paul can only be regarded as a delivery to him personally while the company doesn't exist.
There wasn't...
So the inference would have to be, wouldn't it, that the delivery was to Paul in his personal capacity until he should acquire a more relevant capacity upon the incorporation of the company and his becoming an officer of it.
Yes, my lord, you're absolutely right. But on the facts, it seems that there may have been no delivery to Paul at all. The evidence of Paul himself under cross-examination was that the conveyances were in his father's briefcase up until the time his father went into hospital, and even up until his father's death a few months later. So that it seems that the father retained the conveyances.
Well, if there was no delivery at all,
there was a delivery.
where did that leave you?
No, there was a delivery, my lord. There was a delivery. When he signed and sealed, he delivered it. He signed and sealed it and delivered it.
Delivery doesn't mean handing over.
No, absolutely right.
Necessarily, it may.
No, you're absolutely right, my lord, with respect. I was taking my Lord Sumption's point that if it's in the hands of the counterparty to the deed, then one has to look at it perhaps in a certain way of how it's got into his hands, why it's got into his hands. Is that because there's been a full delivery and no escrow, or is that because one implies that he is receiving it pending the creation of the company in his role as prospective director. So I would adopt that as the latter suggestion, but it seems on the evidence that father didn't hand the conveyance. He delivered it, we say, as an escrow. He didn't hand it over to his son. He kept it in his briefcase. But if he delivers it as an escrow, then when the company incorporates, that's a condition, it's automatic, which fulfills the deed, and the deed is automatically delivered at that point as a deed without any need for any further delivery. And just one extra further point on the Utrecht Magis Welliac and Periac point. I noticed in the Windsor refrigeration case, I don't need to take you to it for this point, but 1961 Court of Appeal case, Sir John Arnold QC was counsel in that case.
Should we turn that up?
We can. So, tab 10. And the electronic page I was referring to is page 466, which is in the bottom right. No, that's not Sir John. That's not John Arnold. In fact, John Arnold isn't in this case at all.
Oh.
I've got the wrong case. What I've given you there is 466 is the same reference to relation back.
Where do we get that?
Page 466, about a third way down the page.
The dating back of an escrow.
The dating back of an escrow is confined to matters of title, where the escrow passes in a state, the instrument is executed on such and such a day against a condition occurring later. When it occurs, the estate vests from the earlier date. The performance of a condition making deed take effect does not, however, have the result that it takes effect as from the date of execution. There is no case in which a document was held to be invalid by the doctrine of relation back. That's counsel. That is John.
Yeah. That's Mr. Arnold's submission.
It is a submission, yes. And I adopt that submission from where he says there is no case where the relation back has destroyed the validity of the...
Is it dealt with?
Has invalidated the deed.
Is it dealt with in the judgment at all?
No, that specific point, that specific point about there being no case is not dealt with in the judgment. The judgment deals with this point. That it didn't particularly arise in that case. No, it was dealt with, but bypassed at page 474, and it's on page 474. It did come up in the later case of Allen Estates and WG Stores Limited.
Right, where is that?
Which is at tab 14 of Authorities Bundle. The Master of the Rolls dealt with this particular point at electronic page 528, starting 4 lines down from the top. The title then said to relate back to the time the document was executed and delivered as an escrow. This only means that no further deed or act is necessary in order to perfect the title of the grantee. As in the grantor and grantee must be regarded as a valid transaction which is effected to pass the title of the grantee as at the date of the escrow. But the doctrine of relation back does not operate so as to affect dealings with third parties. It refers to Butler and Baker's case, which took me a very long time to find and even longer time to think I understood. But the matter is again dealt with in page 528 by Sir Dennis Buckley at C, electronic page 535. When the conditions of escrow are fully satisfied so it becomes an immediate operative deed, that effect relates back to the date of its delivery in escrow, but not for all purposes, only for such purposes as are necessary to give effect to the transaction. He refers to Lord Ross of Chelsea. while it's not specifically relevant to the legal argument, it's interesting to see that in the Court of Appeal in the Bahamas, in this case, they relied on Security Trust Co., which itself was a Bahamas case. And they refer to the decisions in that case, at first instance in appeal, in the Bahamas, where the doctrine of relation back was held to apply. But in the Privy Council in Security Trust, the doctrine of relation back was recognised, but actually was held not to apply, that the judges had got it wrong. That was a case where the flexibility of that doctrine was actually recognised, rather than, as the Bahamas seem to treat it, as an inflexible doctrine which applies willy-nilly.
So if you're conveying land which is let on a rack
Yep.
in escrow,
Yep.
the vendee or the purchaser wouldn't be able to collect the rents from the tenants until the conditions were satisfied. But as between him and the vendor, any apportionment of rents would be as at the date of the conveyance, the original date of execution.
That seems right.
Yeah.
Yes, that seems right. Absolutely.
But the validity as between the vendor and purchaser would also affect anybody seeking to stand in the vendor's shoes, presumably. I'm just trying to think how that applies to the parties in this case.
No, well, in this case...
It may not matter.
In this case, it doesn't matter.
No.
Because of the way, the sequence of events. Because...
Yes. He'd already conveyed the land to somebody else, but she hadn't registered.
Exactly. Yeah. It was a previous conveyance in this case rather than an intermediate one. But she hadn't lodged for registration, odd enough. You will have noticed that in first instance, the trial was essentially about whether her gifts had been forged. But that failed, partly because the witnesses weren't cross-examined, but also because the experts' comparative material was not strong enough. So I haven't taken to it specifically, but it may be worth just looking at the Bank of Scotland and King, Mr. Justice Morgan's case, which is at tab 15, electronic page 538. And he deals with escrows on the electronic page 549, from paragraph 47 onwards. That was a somewhat unusual case on its facts, it has to be said. There was a £1.5 million property which was being sold at that price. The purchaser was obtaining a mortgage of 1.2 million, which is, I think, 80% of the property's value. He paid over on completion about, I think, 1.14 million pounds, which was sufficient to pay off the indebtedness of the vendor, who then remained in the property. Now, presented with those sort of facts, one suspects that some kind of illicit mortgage arrangements going on. It's an odd transaction. But there was an argument that because the full purchase price there had not been paid, that the vendor had executed his transfer in escrow pending the full payment. Mr. Justice Morgan's decision was that while he would have been prepared to accept that as an appropriate way to approach the case on the specific facts of this case, because the vendor knew he was to get the monies he needed to pay off all his own borrowings, and a mortgage was necessary for that purpose. And because when the transfer was sent, it was sent by his solicitor saying, this is the transfer, here it is. We sent it off after the money had come through, but not the full amount, that in that particular case there was no escrow. But he sets out his approach. The question is at paragraph 47, whether the TR1 was an unconditional transfer or was it executed as an escrow on condition that the first dependent paid the balance of the purchase price. Because the first dependent never did pay the balance, the transfer never became effective. Paragraph 49, the law's instruments delivered in escrow can conveniently be taken from paragraphs 37 to 39 of Halsby's Laws of England. And what then follows is a word for word, there are one or two words different, word for word quotation from Halsby's Laws of England. It's a little bit unusual because at paragraph 50, he expressly quotes and insets from Halsby's Laws there, but in fact, those paragraphs are all Halsby's Laws set out. Paragraph 52 is, it's all worth reading, my lords, but if I can just take you to paragraph, well, he makes the ut res magis veliat quam periat point in paragraph 51. Paragraph 52, he quotes from Thompson and McCulloch, Lord Justice Morton, who himself quotes halfway down from Baron Park in Bowker and Burdekin. You are to look at all the facts attending the execution, to all that took place at the time, and to the results of the transaction, and therefore those in form of an absolute delivery, if it can reasonably be inferred, delivered not to take effect as a deed till a certain condition was performed, it will nevertheless operate as an escrow. And that's that point we were discussing earlier. And then paragraph 53, there's more of the same about
if
the
there is an
inferences.
implication in this case that the deed is to come into effect upon the company being incorporated, is that time limited or is it indefinite?
That's a difficult issue on escrows generally.
Yes. What do you submit the answer is?
It's, according to Lord Denning, that there is, if that does not occur within a reasonable time, then the grantor can resile from his deed. That's what Lord Denning says.
Yes.
I think it's the second of the cases. But
if the grantor doesn't resile, for example, because he's dead, is it indefinite? I mean, of course, his estate can resile, but I just have a slight feeling of discomfort at the notion of an indefinite executory
because it seems to put a
transaction.
dead hand on a piece of land,
Indeed.
which is unattractive.
Yes.
In practical terms, it's the question of whether the company itself is incorporated or not. And that is likely to happen within a short span of time.
Well, it could be so.
It could be so.
But not necessarily. Let us suppose that, owing to some mishap, the company wasn't effectively incorporated, and they woke up to the problem 5 years later. And I wonder whether the practical problems are sufficiently resolved by allowing the grantor to resile.
Well, if the grantor didn't resile from it, his estate could resile from it.
Well, all right.
That wouldn't.
Either of them resiling.
Yes.
I mean, it may be that the condition of a reasonable time is to be imported into whatever conditional intention one imputes to these.
Well, that would certainly be a sensible step to take, and that reflects also what Lord Denning's own approach.
Well, apart from the fact that he thought that if a reasonable time passed, the grantor could resile, leaving it open to the construction that it continues indefinitely if he doesn't.
Yes, but if he took another step, if he conveyed it to a third party, that would be an effective resiling from this. Whether when the company then incorporated could argue that it wasn't a reasonable time, or that principle didn't apply. I accept that these are points that arise in theory. Whether they would ever arise in practice is difficult to say. But if one says that one has a reasonable time to fulfill the condition, and that the grantor can resign within once that reasonable time has passed, that ought to.
Does the problem sometimes arise when a company's been struck off and nobody realises it?
Well, so that you don't realise the company's been struck off.
It does sometimes happen, doesn't it?
It does, absolutely. And I was searching for other possibilities, factual possibilities, and that one, unfortunately, didn't strike me. It does happen. There are now...
Presumably either side can apply to restore the...
Yes.
Yeah.
And there are limited periods now, I think, in which one can apply to restore. So that
Okay.
that closes off that to a certain extent.
I think I have a conceptual difficulty of a condition consisting of the coming into existence of the named counterparty to the transaction.
It's a conceptual difficulty. It's not a practical difficulty.
No, I think I accept it's not a practical, but it doesn't mean it's not a difficulty.
What about children?
It is the oddity about it's the oddity about an escrow, though, that there are there are two different views about how an escrow works. One is that while the deed is in escrow, it's not a deed and has no operation. The other is that it has operation as a deed, but it's effective it has operation as an escrow, but its effect as a deed is suspended. But either way, since nothing passes to the counterparty of the deed at that point in time, there is no conceptual difficulty in that person being a party to it at that point, because he's not receiving anything. He's not getting anything. He can't take advantage of it at that point. So if the inherent condition is that it will come into effect when the company is incorporated.
On that basis, you could execute a conveyance or transfer of property to a child who was not merely en ventre sa mère, but not even conceived.
I hadn't thought that. I thought one could do it to a child who's en ventre sa mère. Could do it to execute it in favour of a child who's not conceived.
Firstborn.
Then you then haven't identified the child. But if you execute a deed in favour of your first child to be born, prior to any child even being conceived.
I mean, of course, you can declare yourself a trustee of property in those terms, but that's a rather different question.
Well, in fact, it isn't a different question, my lord, because a conveyance to a minor takes effect as a declaration of trust in favour of the minor. So it may be that you have declared a trust in that way, and if you can declare a trust, if you did a conveyance to somebody who was a minor, and that takes effect as a declaration of trust, it may be that the unborn child again will work. The fact is, however, that sometimes there comes a cut-off point in these cases where one says, no, that is you have reduced it to the absurd. Let's not go there. But in the practical, here we have a very different arrangement, father and son incorporating a company together, effectively. And as part of the transaction, the documents are signed, and very swiftly after, the company comes into being. I'm conscious that I seem to have left more points up in the air than I've actually solved in the course of these submissions. But you have my submissions on them, and I hope that you will feel that they have the force necessary. I think within the time allotted, I better be moving on to the section 22 point, unless there are any other specific
Let's move to section.
rockets you want to launch. No, good. Section 22. We need to show, seems to be three things. One, that the conveyances were written contracts. Two, that there was an adoption. And three, that the adoption was within a reasonable time of the incorporation of the company. Were they written contracts? My basic submission on that is that these indentures, these bipartite deeds, were the embodiment and writing of the contract between the parties. There was no pre-existing...
Between which parties?
Well, because it's a pre-incorporation
Yes.
contract.
I mean, it purports to be a contract with a non-existent body, so it's a unilateral instrument, at least until the body comes into existence.
Well, absolutely right. But the statute presupposes that you can have a written contract with a company that has not yet been incorporated.
Does it? I
does
think
it
we
really?
supposed you had a contract with the person who was purporting to act on its behalf.
Yes.
It's not specifically addressed to the case of pre-incorporation contracts, and it doesn't happily fit within that situation.
It is pre-incorporation contracts.
Oh, sorry, yes. Yeah, no, sorry, you're quite
Incorporation
right. Yeah.
contract.
Sorry.
It says,
Yeah.
except as provided in this section, a person who enters into a written contract in the name of or on behalf of a company before it is incorporated is personally bound by the contract and is entitled to the benefits of the contract.
I mean,
So who do you say that was? You say that...
That was Paul. That was Paul Rolle. He's the individual. He signed one of them. He's the man who's there. There's no doubt about that. But this presupposes conceptually, at least, that there's a contract between one party and...
this is a gift, wasn't it, to the company?
Well, it was a nominal consideration.
There was real consideration.
Oh, was it?
It was
$100.
Oh,
Bahamian
sorry,
dollars.
yes.
Ina Rolle, she had a gift. One can only suspect that Mr. Holowesco, the attorney, saw this point being developed before your lordships many years hence and thought he would give not just nominal consideration, but real consideration, but small. It was 100 Bahamian dollars.
Yes.
So it's it's a contract. I say because it's the embodiment of the, in writing, of the contract between the parties. There's an underlying conceptual contract, at least, with the company, and it takes effect as a contract with Paul Rolle. But on any footing, this document, I say, is a written contract. It's in writing. One of them was signed. One of the documents, one of the conveyances was signed by the company, but it doesn't. There's no requirement that the written contract should be signed. It's just that it should be written.
Is there a section? Is there a section 40 in the Bahamas?
There is. It's a statute of frauds section. I got my June to look that point up, and he assures me I haven't brought it before you. But there is such a provision, yes. But so we have a contract, potentially at least. The fact that it's by deed doesn't prevent it being a contract. Many contracts are under deed, under seal, they're in deeds, and so the form of the contract itself doesn't rule it out from being a written contract.
And you presumably say that it's not implicit in section 22(1) that the contract be in any way executory.
No, it doesn't require that at all. And why should it? Because the interesting thing about section 22, in comparison, for instance, with section 50 of the Companies Act in England, is it's Section 22 is there to assist all parties effectively against the complexities and unsatisfactory state of the common law before that section was introduced. Section 50, on the other hand, is there only really to protect the counterparty. There's a different role. But here, this Section 22 ensures that all parties have not only clarity, but have established rights under a pre-incorporated contract, because the counterparty, in this case, Emmanuel Rolle, can enforce against Paul, where was there anything executory under it to enforce.
The equivalent English rule is page 368 at tab 4, is it section 51?
It is, absolutely.
And the difference is that it makes the promoter liable, but does not give him the opportunity to enforce, is that right?
Probably not. It specifically states that the promoter is liable, because that seems to have been the purpose of it originally, but because it takes effect as a contract between them, he will be able to enforce it too.
So he will. Yeah.
But the particularly significant difference is that the company cannot adopt it. So the company, once it's incorporated, doesn't get any rights under English statute. It will have to go cap in hand and try and work on an innovation. It doesn't get adoption rights.
Has there been suggested any policy reason for not extending it to conveyances such as this one? From what you're suggesting, well, now I'm thinking about in
Bahamas.
Bahamas, I mean, you're saying it's a provision intended to protect both parties from the common law complexities.
Yes.
It would suggest that it would be sensible to extend it broadly, and still think of a policy reason for not including conveyances such as this case.
No such policy reason of which I'm aware. What's interesting is that in the one, Section 51 in England we've been looking at, when it was brought into law in 1972, it was by the European Communities Act, and it was Article 7 of the Companies Directive, brought it in, along with the ultra-vires, watering down of ultra-vires. This was, I think, Section 9.2. It didn't specifically apply to deed. It was just introduced as pre-incorporation contracts. And somebody since then, and I'm afraid we haven't traced that point down, but somebody since then has decided that, oh, that's a little bit unclear or uncertain or unhelpful, and has extended it to deeds.
Yeah.
In the Bahamas, it is simply in terms of written contracts. So in one sense, it's wider than Section 51, which is just a contract.
Yeah.
And it's wider. The Bahamas adopted, it seems to me, they adopted the Canadian model because it's word for word, apart from a slight stylistic difference. And also the Canadian model includes oral contracts, not just written ones. But they adopted the Canadian model, and there is a interesting, what one of my leaders used to call the wider sense, an interesting discussion of that in Sherwood Design Services Limited at tab 18 in the dissenting judgment. He goes into the Canadian dissatisfaction with the common law and how they brought in statute to reform the common law and to ensure that all parties in it knew exactly where they were, had all the rights they needed. And one of the pieces of Section 22, which is easily overlooked, in fact, is subsection 4 of Section 22. If we're looking at tab 2, election on page 361, subsection 4 says, except as provided in subsection 5, that's where there's express agreement, whether or not a written contract made before the incorporation of the company is adopted by the company, a party to the contract may apply to the court for an order under which obligations under the contract may be fixed or being joint and several for apportioning liability between the company and a person who purported to act in the name of the company or on its behalf, and the court may make any order it thinks fit. So there's an inbuilt remedy, an inbuilt, almost discretionary remedy, at the instance of any of the three, the counterparty, the promoter, or the company, to determine what the actual liabilities are or ought to be under the contract. So it's given a quite full powers there. And a provision of that kind, in my submission, is indicative that this is intended to be a wide.
Is that also in the Canadian model?
Yes, it is. It is. And so there's no reason, I say, to infer that because something's a deed or conveyance, it should be excluded if it does also amount to a written contract. If as here, we have the embodiment of a sale transaction in the conveyance. We have the quid pro quo on both sides. We have the agreement, and we have the intention to create legal relations. It's said against me that because the document is actually a grant, that it can't be a written contract. But land lies in grant. It's an odd thing. It's the feudal, as it were, the feudal history of the English law. The land lies in grant. But the reality is that where you sell land, the grant is part of that sale transaction, part of that sale agreement. Here we don't have to worry about pre-existing contracts for the sale of the land because there weren't. That's accepted on all sides. They went straight to the conveyance. There are many contracts, of course, where title, property passes at the very instant the contract is formed. That particular fact doesn't prevent such an arrangement from being a contract. There are many contracts where there is nothing to perform between the parties immediately after the contract is made. There may still be contractual obligations and contractual rights, if you like, that are inferred or that can arise, but that very typical contracts will take place with property passing and money being paid at exactly the same time. Not surprising at all. In fact, that's the sort of arrangement which most contracting parties are aiming for if they can get it, because it's the best one. It's the arrangement by many computer-generated contracts nowadays. Not until you hit the PayPal button do you get anything. And at that point, for instance, a train ticket, the ticket is, you can print it out. You have the ticket at exactly that point. There is, in fact, in one of the two contracts, there is an executory obligation on the part of the company. That is to respect the Crown's rights, and it's a covenant to respect the Crown's rights and minerals, rights in the minerals under the land. But in my submission, you do not need there to be such executory or outstanding obligations for the arrangement in the two parties to be seen as a contract, and it's certainly a written one. said that a conveyance shouldn't be, against me, that a conveyance shouldn't be treated as a written contract for this purpose, because third parties might be prejudiced if they acquired property rights subsequently. So that I think the argument is that because property rights are concerned, you must treat conveyances differently from normal contracts. Well, it's not necessarily true, of course, because a normal contract in relation to personal property will itself deal with property rights in that personal property. A valuable painting, for instance, there can be items of value, intellectual property rights, which can pass by way of contract and don't need conveyances. But, of course, the Section 22 doesn't interfere with property rights. It creates definite property rights in the promoter until adoption takes place. And then when adoption takes place, the company gets the promoter's rights and liabilities. So there isn't any hiatus here. There is no lack of clarity and no potential prejudice. Should any occasions arise when one of the three parties involved in this statutory menage are uncertain about where they need to be or what they need to do, then they have the right to apply to court. Now, accept that those rights come with costs, but they have that opportunity.
So far as property rights in land are concerned in the Bahamas, there is a system of registration of deeds.
There is.
Not rather than a land register.
There is. Absolutely right.
And the priorities will be determined by date of registration,
exactly.
Section 10.
Yes, exactly.
So whatever property problems might arise in relation to property not covered by Section 10, it doesn't arise under Section 10. You determine ownership by priority, which of course is what all this dispute is about.
Yes. Your Honour is entirely right, and that was a point I had to make, but I'd rather lost track of it. But the proprietary difficulties, priority difficulties, are dealt with by their very simple lodging for registration, lodging for record legislation. Somewhat different to ours, but very simple. The order of lodging for record is what dictates the priorities. And by another extraordinary quirk in this case, it's the order of lodging for record, not actually the recording of that, because oddly enough, Ina Rolle managed, although she lodged later, managed to get hers recorded earlier. Paul Rolle's, his lodging seemed to have got lost in the office, but the statutory date is the date you lodge for record, and that's where the priority arises. So yes, so it doesn't give any rise to any problems. We say no reasons for policy why it shouldn't apply to conveyances, because their priorities are dealt with elsewhere. So the obvious position which we submit is inescapable, that these are written contracts, must apply, and we don't need to look at the merger point, because although that featured heavily in Chief Justice Barnett's argument, that was on the assumption that there was a pre-existing written contract, which there wasn't. So it's not a point which arises, although I have my answer to it if necessary in the case. The next point then is whether the stamping of the conveyances, which is a rather more than nominal amount, and the lodging with them for registration, amounted to any action or conduct signifying the company's intention to be bound by the written contract, and therefore affected the statutory adoption by the company of those contracts. And this is one of those more difficult points for the advocate when he can't see what the argument is against him. And so it just seems so obvious. It goes without saying that that must be the case. The action or conduct, it's said against me that there ought to be some kind of notice to the counterparty that you intend to be bound by these documents. That itself would exclude any company that wasn't aware that there was a defect. So it casts a whole load of companies adrift, if you like, whereas in reality, in the commercial world, these things may happen. And if a company gets on and operates on the basis that it is a counterparty, it is a party to the contract, then why is that not an action or conduct signifying that it has an intention to be bound by that contract? It must be, in my submission. What one's looking for. The whole concept of action or conduct shows that it is the practical commercial step that the company takes in relation to the contract, which is what amounts to an adoption.
If the instrument was ineffective at the outset, I suppose it wasn't ineffective if it vested in Paul.
Exactly.
Yes.
You've got absolutely right. It's easy to forget that. One's looking very much from the point of view of the company, but it's easy to forget that the adoption by the company simply creates as it were, a statutory transfer from the promoter to the company.
But, I mean, does Paul not have to know? I mean, I can see on the facts of this case he inevitably would, but do you not at least have to signify to the person who would otherwise be bound that you have effectively relieved him of his obligations? Because the company has done that.
In this case, we needn't trouble ourselves with that on these facts.
But looking at it at a theoretical level, it's somewhat difficult to imagine that you can adopt something without telling anybody.
Without
I suppose you might say that by
apart from your own agents.
Oh yes,
registering
I
it,
do say
telling
that.
the world.
I do say, but there I'm having to rely on the facts of this case again. Yes, the point is that the registration is notice to all the world. It's the best. It's the best form of notice. It's better than taking an ad out in the paper.
Is there a statutory provision to the effect that in this form of registration, people are treated as having notice? Because there are some registers of deeds where you get notice to the world. There are other registers of deeds which provide your priority, but it isn't treated as notice.
When you asked me the last question about the registration of deeds, I was getting a bit nervous that I wouldn't be able to answer. And at this point, I do not know the simple answer to that. If one looks at that section, it's in registration of records.
Yes.
Act, which you've got at tab 1. It just states about it being about giving priority.
Yes, I just looked at the arrangement of sections and I didn't see any obvious provision which discussed the effect of registration in terms of it being noticed to the world.
But it's the registry of public documents.
It's the registry of public documents. That's the whole. That is its purpose. And if one looks at the last few lines of paragraph of section 10, it shall be accepted for record. The one first lodged and accepted for record shall be deemed and taken to be good and valid, and shall in no wise be defeated or affected by reason of priority and direction of any other documents. So.
I mean, registration wouldn't work if it wasn't a public register.
Yes, you've got to be able to look and see. I'm interested in that land. I want to go and see it.
That is true.
That is true.
In Scotland, we had a public register of documents, the Register of Sazines, and we had a separate book of council and session the latter was deemed to be deemed to give rise to public knowledge. The former wasn't, but of course you could produce your title to defeat a rival claim. But it may not matter in this particular case.
No.
And the trouble with deeds registrations, it's a bit of a lottery whether you find it or not, because whereas land registration, you just go straight to the registered title to the land which you're thinking of buying or taking an interest in. I think that's right, but I don't pretend to be an expert.
Yes, and I haven't seen what insurance provisions there are. Or
Deeds may be registered against names rather than
Yes, I think you
places,
search
mayn't they?
names.
yes, then you have the.
I think you search names.
And then you have that old problem about if you get the name bang on or not. Yes.
I suppose that in practice means you're thinking of taking a conveyance from Mr. X, then you can do a deeds registry search to see if Mr. X, a deed with him as the vendor, has been registered.
And that was
Then
the
you
way
look
we
at all
did it
the
under the old Land Charges Act, that
Yeah.
one did a whole number of
Yeah.
permutations of names
Yeah.
to make sure one got as the best coverage one could get. But perhaps in response to Lord Sumption's point, the promoter who is liable under this contract is liable because he's the promoter of the company. If he and the company lost touch, A, is that likely? If the company's adopting
Well,
a
it might have been
contract.
sacked.
Yeah, you might be. And yes, and he might, or somebody else may have taken the company off him. It's absolutely,
Precisely.
it does happen. But he is at least aware of what is going on, aware that the company is being active. And it would be very unusual if he wasn't aware. He has, after all, entered into this contract himself on behalf of the company. He may have no knowledge of the intricacies of the statutes throughout the globe which give him himself the rights and liabilities on that contract. He will be expecting the company to take it over from him as soon as it's incorporated. That's his point in doing it. So it could come as no surprise to him when the company does adopt it. My submission. And it's not just the lodging for registration, it's the paying of the stamp duty on the contract. Stamp duty, assuming that the Bahamas is the same as stamp duty in this country. It's an obligation on the purchaser to pay, and that obligation has been accepted by going to the government and getting the document stamped. So that is an adoption, and shows that the company intends to be bound by the contract, because one of the obligations it undertakes on entering into the contract is the obligation to pay stamp duty.
And as soon as you have registered your title to the property, you'll become liable for all the obligations that are imposed by statute or otherwise on the owner.
Absolutely right, and I'm very grateful to be reminded at that point. Yes, if there are local taxes, all those sort of things, you become bound by those.
Yes.
Bound by the contract. Exactly. So we then come to the final point. Was 8.5 months after the written contract within a reasonable time of the company's incorporation? Chief Justice Barnett said it wasn't. He said a reasonable time after the incorporation cannot, in my judgment, be 4 years or even 8 months. But in my submission, he not only did he not give any reasons for saying that, certainly in relation to the 8 months, the only reasons he gave applied to the 4 years, not the 8 months. But it appears that he hasn't looked at it on the appropriate basis, which we say is that it should be a reasonable time in all the circumstances of the particular case.
Well, normally when you have a condition that something must happen within a reasonable time, the amount of time involved is going to depend on what needs to be done within the period. Now, one possible view is that in the case of a pre-incorporation contract, all that is required is enough time for the company to put its tackle in order. The problem at which this provision is directed is contracts which are known to exist but which have been purportedly made before the company's incorporation. Why should the time required to resolve that problem be any longer than the time necessary simply to carry out whatever formalities of adoption are proposed? It's not, I mean, it's not designed to deal with the problem of people not realizing that the company hadn't been incorporated yet at the relevant time. I mean, otherwise,
Well,
indefinite length, wouldn't it? I mean, can you suppose that they didn't wake up to this problem for 20 years?
My Lord, yes. It must be a factor in my submission that if the company is not aware, if the company was aware that there was a problem, then it would no doubt move quickly if it wanted.
But why should a reasonable time be measured by how long it takes the company to find out, which might be a very long period indeed? I mean, if that's... What would you identify as the things that need to be done within the reasonable time? You say, one, waking up to the existence of the problem, and two, solving it. But the first could be an indefinite period.
In relation to this contract, nothing needs to be done. Because a landowner, a putative landowner, has received a grant of land for which it has paid the full purchase price. So it needs to pay its stamp duty, it needs to pay its local taxes, those sort of things, and it does pay the stamp duty before registration within 8 months. There is nothing a landowner needs to do once he's paid anything in relation to his land. He sits on his land. He may have bought it as a land bank. He may not be using it. He may need to go to his tenants and get the money. But if he does that, that's probably an adoption. But here, if that's all it is, what do we need to do in relation to this bit of land? Absolutely nothing. If it's true to say, if there's an executory contract and he needs to accept delivery, he needs to make payment, he has obligations which factor into that sort of contractual schedule, then absolutely right. He needs to get on with it. But here, there is nothing that needs to be done. It's up to him whether he registers it. If he doesn't register it, he may lose. If the company doesn't register, they may lose their title. But I do say that if they are not aware, they must be given a little bit more latitude than if they are aware and they know what they ought to do, but they take the risk on themselves. Because whereas the English statute is there to protect the counterparty, the Canadian statutes are there to protect all parties, to give them all the remedies they need when they would otherwise find themselves in this strange predicament of almost a limbo, not knowing who, if anybody, is bound by a contract. So, for the subject matter, which is, of course, the one matter I don't mention in paragraph 20 of the case, but the subject matter of the contract, its nature, is particularly relevant concept in a case of this kind. I put other factors down there, whether, I've already mentioned them, whether the contracting company has any further obligations to perform under the contract to the other party. Whether the other contracting party prejudiced or affected by any delay. Now that could be important. Of course, the statute has its own mechanism that says the promoter is in play.
When was the stamp duty paid?
So say the day before registration.
So was that a statutory requirement?
I imagine, if it's like in England, they weren't accepted for registration until it's been stamped.
But is there any requirement for stamp duty to be paid within any specific time from the original convention? I didn't look that up. Yeah. I have assumed no, my lord, because there is no penalty stamp on there. Yeah. But in this country, we would have a penalty stamp, but I don't necessarily know that in Bahamas there would be a penalty stamp. Whether it's an ad valorem stamp on it,
But I don't, whether there'll be a penalty stamp, I'm afraid I do not know.
No.
But I've assumed because there isn't, it wouldn't be. And the same thing happened, we see, in relation to Ina Rolle's deed of gift. She had to have that stamped. Again, ad valorem, but I see no penalty, and that was an even longer period. Is any third party prejudiced or affected by the delay? And again, no, there is no third party here who is prejudiced or affected by the delay. Ina Rolle said on her behalf that she was prejudiced and affected by the delay, but she wasn't. She wasn't prejudiced and affected by the delay. She was prejudiced by the conveyances. She was prejudiced by their lodging.
She might have been benefited by the delay.
Well, that's the point.
Exactly.
But where there is a registration system,
Yep.
where title priority is determined by date of registration, then delay is positively beneficial to the rival.
I'm grateful. Very grateful. Yes, and the Emmanuel Rolle wasn't prejudiced by the delay at all. Didn't live long enough to be prejudiced by much of the delay, but he was the conveying party. He had the conveyances in his briefcase. He was at that time apparently a shareholder in the company, so there's nothing as far as he's concerned. And again, in the circumstances of this particular case, the promoter, Paul Rolle, he's gone there to lodge it himself, and he's not prejudiced. The promoter could be the person who finds himself in some difficulty, hung out to dry by the company or not knowing where he stands. I entirely accept that, but not in this case. So on the circumstances of this case, no.
22, the reasonable time condition in 22.2, if not satisfied, appears to leave the benefits and burdens permanently with the promoter under 22.1.
It does. Yes, which is an oddity, isn't it?
Does that help in any way for one to get to grips with why the legislature imposed the reasonable time condition? A sort of purposive understanding of what it's there for, sufficient to help put some flesh on the bones of what reasonable means in terms of pure length.
I found it particularly difficult to work it out because, as you say, we have a number of people interested. We have the interregnum, which the company loses the right to adopt. In this case, bizarrely, that would leave valuable properties on which there was no further financial investment to be made by the company in the hands of the promoter. It's an odd outcome that the cutting off point creates that particular windfall.
It looks as if it's there for the protection of the promoter, because prima facie, if the promoter makes a contract on behalf of the company shouldn't incorporate, it's his contract, both in terms of benefit and burden. And the company has an election, if you like, because it was made on its behalf once it's incorporated,
Yes.
to elect to adopt or not adopt it.
Yes.
And the requirement for to do so appears to be there so that the promoter knows where he stands going forward. Is that a fair analysis of the purpose? I can't pretend I'm relying on any authority.
No.
One's just digging around in the dark to see what the purpose is.
Absolutely right, and that is an obvious conclusion from the actual wording of the statute. Sorry, not obvious.
I'm wondering if it might, in part, be for the protection of the third party.
Yes.
Who needs to know who he's attached to.
So if
The third party who needs to know with whom he is in a contractual relationship.
which third party we...
Well,
The counterpart. The counterpart.
Yeah, the counterpart. Yes. He knows he's got the promoter on the hook, but he, if he knows the law.
If he knows the law.
But
there's every likelihood he doesn't.
I know. It's a strange process. You're absolutely right. But certainly he will know. But why why it assists him to know that the company cannot adopt it after a particular period is not easy to understand, unless possibly the company is a shell company, and he's worried that it's going to take it out of the hands of the promoter, which was, of course, one of the worries about the common law in the first place, in some ways. Yeah. Who was bound or who could pay up.
These problems aren't nearly as puzzling when you're dealing with purely executory contracts, which set up a performance regime between apparently two persons and actually between one person and somebody else because of Section 22(1).
Yes, and you need to know who's going to pay, who's going to accept it, all those sort of things. Absolutely right.
And clearly the counterparty can have an interest. Let's say he decides to sue under the contract.
Yeah.
He believes that he is suing the promoter because he's entitled to do so. And then lo and behold, the company says, actually, no, I'm adopting it.
Yeah.
And you've sued the wrong person. I mean, there must be an element of protecting the counterparty.
Yes, there must be. It gives clarity. That's certainly the case. But it is odd that it does seem to protect the promoter more than anybody, if anything.
Mr. Dumont, your...
Yeah, I saw that look at the clock, not at me.
Well, we started a few minutes late, so...
No, not at all. We're very grateful you started at 10, so we could have our 3 hours by 1. Let me leave it now where it lies. I've given you my submissions, and I look forward to a short response later.
Thank you. Mr. Brown? Mr. Mould?
My Lords, I propose to deal first of all with the escrow and then the Section 22 submissions. But before I do so, I think it's worth emphasising what we consider to be the correct starting point. And that starting point is that this involves an ineffective conveyance or ineffective conveyances. And the appellants are trying to save those ineffective conveyances through one of two mechanisms, either escrow or Section 22. However, as our endeavour to explain, neither of those work on the facts of this case. They just simply aren't suitable for achieving the aim that's sought. In relation to escrow, we say there are 3 key flaws. First, a case based on escrow is inconsistent with the pleaded case and the way that the trial was run before the learned Chief Justice. Second, it's inconsistent with the available evidence as a result of that trial. And third, escrow is just simply inapt. So the first of those 3 submissions refers to the pleaded case, and you haven't been taken there yet, so I think it's worth just looking at it briefly. It's behind tab 18 of the paper bundle, starts at page 87 of the electronic bundle. And the relevant paragraphs really are paragraph 3 on the 4th day of September 2006, the law firm of Rolle and Company reserved the name of the plaintiff and lodged the memorandum of an association articles of association with the Registrar General. Next paragraph, on the 8th day of September, a manual roll, $400 over the page, and valuable consideration, duly signed, sealed, and delivered the conveyance, granting and conveying the property described. Next paragraph has a very similar, almost identical wording in respect of the second conveyance. Paragraph 6, that on the 12th day of September, it says 3 days after the execution, I think it's 4, the plaintiff company was duly incorporated by the issuance under the Companies Act of a certificate of incorporated. Paragraph 7, it then refers to the resolution of the 16th of November. There's some deleted passages over the page. You have paragraph 8. It was the intention of a manual roll to convey the said properties, aforesaid lands, to the plaintiff company for good and valuable monetary and other consideration, and in accordance with intentions, the said manual roll entered into a contractual arrangement with the plaintiff company and conveyed the said conveyances so first lodged. Well, there was absolutely no pleading of an escrow, a conditional delivery, even an implied term of any sort. And on the contrary, it might be thought, or it might be said, that paragraphs 4 and 5, referring to duly signed, sealed and delivered, granting, conveying the property, are inconsistent with the idea of a conditional delivery or delivery in escrow. Furthermore, the reliance placed on the resolution in November of 2010 is also inconsistent, because if the appellant was right about an escrow, and that's what had actually been intended, there would have been no need for the adoption of the conveyance in the resolution in November 2010. So therefore, the case that's now put in respect of escrow is flatly inconsistent with the pleaded case. And because of that, it's inconsistent with the way that the case was run and presented at trial before the learned Chief Justice. Accordingly, the evidence wasn't presented as to whether there was an escrow. No cross-examination on this point was made, and there were no relevant findings of fact. There's several other questions. It became evident in my learned friend's submissions that there are several other questions that arise or would have arisen had this issue had been before the learned Chief Justice. What did Emmanuel Rolle exactly know about the incorporation of the company at that time? Were the conveyances in fact delivered at all, or were they just handed to the lawyer as an agent to await further instructions? Why were the conveyances apparently retained by Mr. Rolle Sr.? All of these are sorts of questions that could have been explored in cross-examination and by adducing other evidence had this issue been on the table before the Chief Justice. My Lords, you're unlikely to need much reminding of why it's inappropriate to base an appeal on particularly a point of fact that wasn't relied upon at the trial. I've referred in my case, or in the appellant's case, to the decision of Crane and Sky In-Home Limited, which is at tab 16 of the authorities bundle. I'm not proposing, unless any of your lordships would like me to go to that now. They're quite well-known passages, in particular Lady Justice Arden cites from Lord Justice May from the MB&A and Jones case, explaining what considerations are in play. So we do say, against that background, it's not a very promising start to base an appeal on an escrow argument, particularly when it does involve speculating as to what has happened. If you then turn to the evidence that we do have as a result of the trial that took place in the manner that it did, we say it's quite clear that Emmanuel Rolle's intention was to effect an immediate and unconditional delivery of the conveyance and not to deliver them in escrow. And the clear inference is that Emmanuel Rolle believed the appellant company to be in existence at the time that he executed the conveyance on the 8th of September. And that being so, he can't possibly have intended there to be an escrow conditional on the incorporation of the appellant if he believed that the appellant was already incorporated. You can't infer an intention to deliver an escrow in the face of that intention to effect immediate delivery.
Well, it may be that you could infer a less precise intention, which would nevertheless cover the situation. If the attitude of the grantor was simply, I want this to take effect as soon as possible, I've no idea what formalities may be required, that's a question for the lawyers, but as far as I'm concerned, my intention is that this should take effect as soon as it can.
Well, my Lord, that's effectively imputing to Mr. Rolle Sr. an intention that whatever is necessary to make this effective should take place.
Well, that's not an unreasonable inference, is it?
That might be,
One
but
thing he can't possibly have intended is that the whole thing should be ineffective.
I accept that, but that's not an imputation of an intention for a conditional delivery.
Well, again, I think you may be looking at this in terms that are too precise. A possible view is that you infer an intention that the transaction should be effective and that therefore whatever needs to be done should be done without necessarily inferring any intention as to what the things that needed to be done were.
Well, my Lord, had you had no evidence of the actual intention, then that higher level intention could be one way of looking at it. But on the evidence we have, it seems to be the case that he understood or Mr. Rolle Sr. understood the company to be in existence, and therefore he actually intended an immediate and effective delivery. Now, he may have been mistaken about that. We know that he was mistaken about that. But where the evidence is his actual intention was to effect an immediate delivery, it's very difficult, in my submission, the court shouldn't impute a different intention that, well, I now know, or it can now be said that my intention was mistaken, based on the intention I had, the effect of the transaction was not the effect that I had wanted. Therefore, I will have a different intention imputed to me, because that's essentially what the appellants are saying. We can see that he intended an immediate delivery. However, it's now been discovered there was a mistake, so we will change his intention and impute to him a conditional delivery.
What about the point I put to Mr. Dumont in the parallel with the Bank of Scotland case, where you have a conveyance where people think, well, the donor thinks it's been paid, but in fact it hasn't. And so does that take effect as an escrow until the payment is made?
Well, my lord, that example is exactly an example that I was going to refer to, because in my submission, that's a case in which you can't change the intention. If I proceed on the basis, I'm informed by my solicitor that the purchase price has been paid, and on the basis of that, I therefore effect an immediate delivery, intending it to take effect. It then subsequently transpires that what my solicitor told me was incorrect and the purchase price had not been paid. You can't then go back and say, well, actually, your intention was a conditional delivery.
Well, even if it's only a couple of days delay?
Even if it's only a couple of days, it would be a mistake.
When you assert that, is there any authority to that effect?
Well, the authority that we have for dealing with delivery of escrows makes it clear that you look at all the circumstances. But I'm not aware of any authority where someone has proceeded on a false basis and made an immediate delivery, and it's then subsequently transpired that their understanding was mistaken, and it's been imputed to them to have an intention of a conditional delivery.
And what if he doesn't know whether it's been paid or not, and it's fairly indifferent as whether it's paid, has been paid, or is paid 2 days later?
Well, if he doesn't know, then you may have a greater basis for saying that it was a conditional delivery. But where the evidence is that he knew, he understood the company to be incorporated, therefore his intention, and you're looking here at actual intention, would be to effect an immediate delivery.
Well, the evidence that he understood the company to have been incorporated consists in the deed itself, which refers to the company as if it exists. But that, in a sense, is simply to restate the problem rather than to offer a solution.
Well, the reason why there's not more evidence on this point is because it wasn't run at first instance. Had it been run at first instance, then we would have been able to explore these issues.
One thing we can surely take for granted is that he did not intend this transaction to be ineffective.
The question is whether that's enough.
Well, I hesitate a little, because it is possible that he executed the conveyances and he didn't deliver them at all. So an example, for instance, would be if he gave them to his solicitor to hold to await his further instructions. That would be a possibility, had this been explored. And then, before he gave his further instructions, he passed away. If that were the case, then there would have been no effective delivery at all. It wouldn't take effect as a deed. Now, had an escrow case been run, these are issues that would have been explored. So, based on the evidence that we have, I accept that the inference is that he intended an effective delivery. But, had the issue been explored, that may turn out not to have been the case. But, coming back to the evidence that we do have, apart from the wording of the conveyance, it's important that the conveyance is also dated the 8th of September. And therefore, that is, as a matter of evidence, a factor that's suggesting that the person executing the conveyance intended it to have immediate effect. Had it had a later date, then one would have thought it would have been intended to have an effect at a later date. We also have, there was witness evidence from various of the parties, including Mr. Paul Rolle, who did not give any evidence to state that the conveyance was to have conditional effect. So there's certainly no evidence that this was to have take effect as an escrow, to be delivered conditionally.
And of course, if Section 21(1) applies to it because it's a written contract, it wouldn't need to be delivered in an escrow to make it effective. It could simply confer the rights and burdens on Paul, subject to adoption by the company a few days later if in fact it hadn't been incorporated at that stage. But I understand your case to be, well, it doesn't work under Section 21 anyway.
Yes, Section 22. No, it doesn't work under Section 22, my lord, and I'll come on to explain why. But that's the evidence, and we do support, so I think it was Lord Sumption who commented that there was a distinction between an implication of contractual terms and what you're looking for here. And we say that you're looking here for the actual intention, albeit it may be inferred, it may not have been an express intention, it may have to be implied from all of the circumstances, but you are looking for the intention of Mr. Rolle Senior.
Yes, that seems to be clear from the Bank of Scotland case, because the judge sets out, Mr. Justice Morgan sets out at paragraph 62 a very bold statement, and then says, but the facts are more complex. And the first thing he says is the transfer was given to the first defendant's solicitor under cover of a letter which appeared to suggest that the transfer was effective and certainly didn't contain any hint of any conditionality. Yet, so he looks at the facts that were available to him in order to assess the actual intention.
Yes, my lord, and he certainly doesn't refer to any of the authorities dealing with implication of contractual terms or the like.
No.
So, my lord, that's our position on the evidence. The third point in respect of escrow is that we say it's simply inapt. We say you can't rely upon escrow to give life to a transaction that is void or a document that is void. And you can see this by way of the following examples. If a person lacking capacity executes a document as an escrow, it's a nullity. And it doesn't take effect because at the time the condition is fulfilled, the person has gained capacity. And similarly, if a conveyance is delivered as an escrow when the grantor does not have the relevant property that's purportedly conveyed, it doesn't take effect if the grantor acquires that property by the time the condition is fulfilled.
Well, those are two different situations, aren't they? Because in the first situation, a lack of capacity, you lack the capacity either to convey absolutely or to convey conditionally. I mean, so the rather different considerations apply as between your first two examples.
Yes, my lord, I accept, but they're both focusing on the time of the alleged delivery in escrow rather than the date of fulfilment of the condition.
Yes, but I mean, the difficulty about lack of capacity is that you don't have a capacity to do an escrow either, well, even if you quite clearly express your intention to do so.
That's true, my lord, but it is important, and I'll show you by reference to the Allen Estates case how that relates to the facts before us, and I think it's probably best that we go there now, and that's behind tab 14, which you can find at electronic bundle page 518. My learned friend did take you to this case briefly, and it was a case in which a lease had been delivered in escrow, and the main issue was whether, for the purposes of ascertaining the date from which rent was payable, the lease was to be treated as taking effect from the date it was delivered as an escrow or the date of the fulfilment of the relevant condition. And that was important because there was actually a year's difference between delivery in escrow and fulfilment of the condition. And in the Court of Appeal, the majority were Lord Denning, Master of the Rolls, and Sir Dennis Buckley, and the dissent was from Lord Justice Ackner. If we pick up what Lord Denning had to say at page 520H, and it's 520 of the report, the bottom paragraph, which begins, "Thus far there can be no dispute," it says, "The question in this case is, what is the effect of an escrow before the conditions are fulfilled? One thing is clear, whilst the conditions are in suspense, the maker of the escrow cannot recall it. He cannot dispose of the land or mortgage it in derogation of the grant which he has made. he is bound to adhere to the grant for a reasonable time so as to see whether the conditions are to be fulfilled or not. If the conditions are not fulfilled at all, or not fulfilled within a reasonable time, he can renounce it. On his doing so, the transaction fails altogether. There's no effect at all. But if the conditions are fulfilled within a reasonable time, then the conveyance or other disposition is binding on him absolutely. And he then goes on to talk about relation back, which I won't read out again because my learned friend has already read that out. Lord Denning went on to conclude that the relevant date was the date of the delivery as an escrow. As I say, Lord Justice Ackner dissented, and he thought that the relevant date was the date of delivery as an escrow. But the particular passage I want to take your lordships to is actually from Sir Dennis Buckley, and this can be found at 527F, which is 534 in the electronic bundle. And just between F and G, on page 527, Sir Dennis Buckley says, the substantial point, I think, for the purposes of this question of construction is that the maker cannot resile from the terms and effect of the document which he has delivered, notwithstanding that he may have delivered it in circumstances which for the time being deprive it of operative effect and enforceability. I have laboured this point, perhaps at undue length, because it seems to me to have an important bearing upon the meaning to be attributed to the words the date hereof in the present case. The date was left blank in both the lease and the counterpart, the dates which are now to be found that were inserted later and not by agreement. So we are left to discover the date of the lease from extrinsic evidence. We must surely look for the date when the lease first had some legal effect. That was when the lease and counterpart were delivered in escrow, i.e. November 1st, 1976. True, it cannot then have vested a legal term in the tenants, but it created a state of affairs in which the landlords could do nothing with the property inconsistent with their ability to implement their grant upon the instant of fulfilment of the conditions attached to the escrow. On the facts, the lease and counterpart were both, in my opinion, delivered in escrow on the 1st of November 1976. Now, that's instructive because it explains that an escrow does have some legal effect from the time of its delivery. Now, in the present case before your lordships, the Court of Appeal considered that the doctrine of escrow was inapplicable because it would result in title relating back to the 8th of September, at which time the appellant did not exist and therefore could not have received title at that point in time, and therefore the transfer was void. And my learned friends referred to Lord Cross in the Security Trust and Royal Bank of Canada case. I don't propose to go there now, but in fact what Lord Cross had to say about relation back was actually obiter, because the case was decided on a point of construction, so he didn't fully go into the application of relation back. But more importantly, even if contrary to the normal position with escrows, title in the present case were not to relate back to the 8th of September, there's still a fundamental problem with the application of an escrow. And that's because if the conveyances are to be treated as having been delivered as escrows on the 8th of September, then a manual roll would have been bound and unable to withdraw the conveyance. However, at that time, the appellant was not in existence. So to whom was a manual roll bound? The answer is nobody. For example, who could have obtained an injunction from him preventing a manual roll taking inconsistent action on the following day? No one. Yet if manual roll wasn't bound because there was nobody in existence to whom he could be bound, then the conveyances couldn't be escrows, but are instead nullities. As Sir Dennis Buckley's comments indicate, because the legal force of the document is derived from the action taken at the date of the escrow, it must be capable of taking legal effect at that time. And therefore, the escrow analysis just simply doesn't work. Apart from the fact there's a lack of relevant intention to have an escrow, it just simply doesn't work. And the Court of Appeal's reference in the present case to relation back is really to the point that the escrow has got to be capable of taking effect, subject to the condition, at the time that it was delivered. Well, and that's why we said the escrow analysis doesn't work. I'll deal separately with Section 22. so those are our submissions on escrow. Moving to section 22.
Sorry to drag you back, but I'm a little slow. I understand that last submission, I think, but how does it differ from the submission that effectively the doctrine of relation back operates, can operate to invalidate?
Well, it's slightly separate from relation back. Relation back was certainly in the sense that I think the Court of Appeal, on the face of it, had in mind was title relating back to the date of the escrow.
Yes.
But actually, the escrow, in order to take effect as an escrow, it is a legally valid and, in a sense, enforceable subject to that condition step. It has legal effect, as Sir Dennis Buckley explained. And for Emmanuel Rolle to be bound by that act, there has to be someone in existence to whom he is bound. And if the counterparty is not in existence, then he's not bound to anyone, and therefore there can't be a valid escrow.
But are you...
Yes, the absence of a creditor for the obligations of the grantor, you say, means you don't need relation back.
No.
Yes, so even if relation back is ut res magis, then it matters not, because you don't need it.
Exactly.
I mean, are you submitting that because in the normal case, the grantor is bound not to make an inconsistent transaction from the moment that he executes the escrow, it follows that the title, when it's perfected, has got to relate back to the same point of time?
Well, we don't need to go that far. It would normally.
Yes,
and
I mean, it's difficult to see that it's a requirement. Why should it be?
Well, I don't put my case on the basis that the title has to relate back. I put my case on the basis that for an escrow to be delivered, when it's delivered, the grantor has to be bound by the delivery in escrow. Right. And if the grantor cannot be bound because there is no counterparty... There
can't be an escrow at all if he's not bound.
Exactly. And it's a fundamental part of an escrow, and that's why it is a conditional delivery, is you are bound subject to the condition, and therefore you are bound at the point of delivering the escrow.
I wonder if you're putting, as an analysis deriving from the Allen Estates case, the cart before the horse. What the Court of Appeal were trying to do, as I understand it in that case, is to resolve a dispute between the parties as to whether something delivered in escrow where the condition had subsequently been satisfied had effect from the date of satisfaction of the condition or the date of the delivery of the escrow. And they, I think, held the latter. Yes. And for that purpose, they ascertained, the majority ascertained, that it had some legal effect at a date earlier than the satisfaction of the condition. And they described the nature of the legal effect which it had. But in a case where, let us say, the condition is the coming into existence of the grantee, where ex hypothesi common law, there is no legal effect before that date, which anybody can enforce, why might not that lead to the conclusion, not that the doctrine of escrow has no application, but simply the first time when it had legal effect was the date when the condition was satisfied?
Well, then...
Sorry, it's a rather long question.
No. You would then be giving... Well, what would be the position, I ask rhetorically, in the period between the purported delivery in escrow and the satisfaction of the condition?
It would be, during that period, it would be a unilateral transaction. The grantor could resile, but if he doesn't resile, it may still be the case that his intention was that it should take effect to confer title as and when it was possible. I mean, the fact that he could resile is not inconsistent with the notion of a condition if the circumstances are that he hasn't resiled.
Except, really where you're coming to is that there's no delivery at all. There's just an absolute delivery at the time that the condition is satisfied, because he could resile. So it's not a condition. In that case, what you have is you have a delivery that the grantor can resile from, which is therefore, so it's not then just subject to the condition that the company, for instance, is incorporated. In fact, it's subject to him not withdrawing it, which is no delivery at all.
But the whole idea of escrow, is it not, is that the grantor can't resile.
Well,
he is giving subject to a condition. If he can resile, there ain't no escrow.
Exactly. And
You're saying that an escrow is a present conditional intent, not some indication of a future intent.
Exactly, my lord. That's one way of putting it. So we really have two main submissions. Is one that, given the way the case has been pleaded, the way it's been run, and then when you look at the evidence, you shouldn't come to the conclusion there was an intent to have an escrow. But secondly, and really reinforces the point of the lack of intention, is that it just doesn't work as a matter of legal analysis. Turning to section 22, again, the starting position, at common law at least, is that a pre-incorporation contract purportedly entered into a proposed company is void. If it is entered into in the name of an agent, it may be that the agent is bound by that contract, but if it's entered into in the name of the soon-to-be incorporated company, then the contract is wholly void. That's the position at common law. And several jurisdictions have intervened by way of statute, including the Bahamas, and we have section 22, which you've already looked at in terms. We say that the reliance placed on section 22 is misplaced, and we have three, but it may only be two submissions now. One is that section 22 has no application to a deed of conveyance. And second, in any event, the appellant did not, within a reasonable time after it was incorporated, signify its intention to be bound. My third submission was going to be in relation to the new point made in section 22, which I think my learned friend admitted was a brainwave when he was drafting his case. I'm not sure if that submission is still relied upon. I'll say something about it very briefly at the end. We have addressed it in our case in any event. But the first main submission is in relation to the application of section 22. And we say it's quite clear that the policy or the purpose of section 22 is to make promoters liable on pre-incorporation contracts. And that purpose is far removed from validating ineffectual transfers of property to non-existent entities. Yet that is what section 22 is being relied upon for the present case. And that may well explain why the appellant conceded before the Court of Appeal that section 22 had no application, and that concession the Court of Appeal thought was correctly made. The conveyances are being relied upon as transfers of property. And that's important because in order to transfer legal title, the conveyances need to be in the form of deeds. And accordingly, unless they took effect as valid deeds, there would be no valid conveyance of title. However, as I've already endeavoured to explain, because the appellant, as the grantee under the conveyances, was not in existence at the time of the conveyances as deeds were nullities. And it follows, because they're nullities as deeds, they were not effective to transfer title. And section 22 does nothing to change that. It deals with pre-incorporation contracts, not with ineffectual deeds, where a deed is required to transfer the title. So we say whether you can actually construe either of the two conveyances as written contracts is in a sense irrelevant, because what they are being relied upon is a transfer of title and a deed of conveyance to do so. But I do take slight issue with the suggestion that the conveyance behind tab 29, which your lordships will find electronic page 233, behind tab 29, I take issue that this can be fairly described as a written contract. Although the company is named as a party to the conveyance, it's not been signed or executed by the company, but the operative provisions say, in pursuance of the said agreement and in consideration of the said sum, the vendor hereby grants and conveys unto the purchaser all the said hereditaments. You see, that's a straight conveyance. If there was any pre-existing contract, it's the performance of the contract by transferring the title. It itself is not a written contract. It's particularly clear in the conveyance behind tab 29.
So there may have been a contract, but it's not in writing. Is that the point?
Yes, my lord. It's unclear whether there was actually a pre-existing oral contract. One would think that there probably was. They didn't just enter into this conveyance without discussing it. So there is likely to have been a pre-existing oral contract, and this is the performance by the conveyance of the land. Now, had the legislator intended Section 22 to encompass the adoption of deeds of conveyance or other property transfers, then one would have expected that to be provided for expressly. And your lordships have seen the statutory provision in England, which is behind tab 4, section 51 of the 2006 Companies Act, which makes, although the terms of the provision are different from section 22, it makes express provision dealing with deeds. So, were conveyances or deeds to have been intended to be caught by section 22, one might have expected a similar provision to have been made.
Is there any policy reason for not extending it to deeds?
Well, my lord, we made a point in our case that there is usually considered to be a distinction between contractual interests and property interests. So the doctrine of privity of contract prevents contracts from imposing burdens on third parties, and therefore the ratification of a contract by an unincorporated company is less likely to prejudice a third party, whereas the subsequent adoption of what might otherwise be a void property transaction, or it being caught by section 22, is more likely to interfere with property transactions that might have taken place since the alleged transaction, whereas if it's restricted to contracts, the interference with third-party rights is less likely. So that's a potential policy reason for restricting the definition of section 22. Well, I now propose to move on to whether there was an adoption within a reasonable time. Now, first, there's two sub-issues to that. Was there an act of adoption? And second, was it within a reasonable time? And the first point we say, and we don't press this particularly forcefully, but we do pause to question whether actually the registration of the conveyances is necessarily itself an act of adoption in accordance with the language required under section 22. What is required is for the company to signify its intention to be bound.
But if it did something which unequivocally showed an intention to become the proprietor of the land, it must have intended to assume any obligations that went with that.
Well, it's when you drill down to that went with that, because what we have here is apparently a contract by which $100 was paid for some land and a conveyance was made. Now, the registering of the conveyance by the company might be said to be consistent with an adoption of, or assumption of title, adopting the benefit of the contract. But what is required under the statute is signifying its intention to be bound. Now, it doesn't necessarily mean that the company was saying, well, I'm accepting that I'm bound by the obligations under that contract.
Suppose that there are no more executory obligations. Does Section 22 not apply at all?
Well, perhaps not. It's difficult.
Well, I'm not sure that perhaps is a basis on which one can analyse this. Is it or not?
Well, if you need to signify an intention to be bound by something where any obligation has already been performed, so there is no longer anything to be bound by, it's rather difficult to signify that intention if the contract has been fully executed.
Although if you look at section 22(3)(a), the purpose is to give you both the burden and the benefit. It seems a little odd that a company could signify validly under section 22(2) an adoption for the purpose of undertaking burdens, but could only signify the adoption of the benefits if there was still some executory burden to be performed.
Well, it's
notwithstanding the language.
It's a little difficult with fully executed contracts. It's a little bit odd where you have a sale of something where there are no longer any ongoing obligations. It's been fully executed.
Does it mean any more than signify its intention to be treated as a party to the contract?
Well, that might...
For what that might involve, for better or for worse?
That might be what's intended. I mean, it's not the language used, and that's why we don't...
what it means.
We don't press this too strongly, but
no.
The only point that I endeavour to make is that it's not necessarily the case that by taking the benefit you have signified an intention to be bound by the obligations. I leave it like that, but that's why we pause to before we accept.
I mean, your real point is the 8.5 months is too long.
Yes, exactly. And my Lord, the learned Chief Justice rejected 8.5 months as being a reasonable time after incorporation. There was no appeal against that finding. The question of what constitutes a reasonable time is a question of evaluation, we say, primarily for the trial judge. And an appellate court should only interfere with that decision on the usual limited grounds. So, for instance...
The trouble is just saying it's too long isn't much of a statement of principle. The judge doesn't seem to have addressed too long to do what? A reasonable time to do what? Because that's going to determine how long a reasonable time is. It can't be simply, well, this seems an awfully long time to me. There's got to be something a bit more precise than that.
What the learned judge did say is, and we say absolutely, and this is common ground, absolutely applied the correct test, is he said it's not time from the discovery of the mistake, it's time from incorporation. And in terms of what needed to be done, it's not what needed to be done to register title that's relevant. It's all that needed to be done was to signify an intention to be bound. All you need to do was draft a resolution. I mean, they did that when as soon as they discovered the mistake, or after they discovered the mistake, they drafted a resolution adopting it. And no one suggested that that resolution wouldn't have been a signifying of intention.
So you say that a reasonable time is a reasonable time in which to make your intention clear.
Exactly.
And that's all.
That's all that you need to do. And if you can, next day you can draw up a resolution.
You even need a resolution. What happens if the managing director simply writes a letter?
Well, that would be sufficient. I mean, it takes no time at all to signify your intention to be bound.
I mean, the critical point is you say that it's not a reasonable time to find out that there's something you need to do. It's a reasonable time to do it.
Exactly. And The whole purpose and the reason for the qualification of reasonable time is to avoid uncertainty. And in our respectful submission, it's primarily dealing with the position of the counterparty and potentially other people dealing with the company, because they need to know what the commercial or financial situation of the company is. And particularly the counterparty needs to know whether he or she's in a contractual relationship with the promoter or with the company.
Well, that may depend on the terms of the contract.
It can, and if it's an express stipulation which is provided for under Section 22.5, then it can be an express stipulation that Section 22.5, if it is expressly so provided in a written contract, a person who purported to act for or on behalf of a company before it was incorporated is not in any event bound by the contract.
That's contracting out of the section.
Exactly.
Yes. Sorry, I was putting a rather more mundane point, that if the contract isn't executory on the part of the counterparty, you may have no obligations to perform to anybody. I mean, assuming against you, but purely for the purpose of analysis, that this conveyance is a written contract for the purposes of Section 22, why in this particular case should it greatly matter to transferor whether the property is vested in his son Paul or his son's company?
Well, it depends if you're going to look at all of the circumstances rather than focusing on the period between incorporation and what needs reasonably to be done to adopt it, then there could be reasons. I mean, the ownership of the company may have changed in between the time of conveyance. I mean, one important factor or one event that did happen is that Emmanuel Rolle passed away. Now, had in fact an act of adoption taken place before he died and he had been given notice of it, he may have been around so as to resolve this issue of why he purported to convey the same piece of land both to his son and to his daughter. So if you're looking completely in the round about all the factual circumstances...
It can't be a reasonable time in which to sort out a dispute. It's got to be a reasonable time to do something relating to the perfection of the transaction.
Well, exactly.
I mean, I would have thought your strongest point is simply that this is, when one's talking about what the assets and liabilities of a company are, there is every reason to think that they should be determined as soon as possible, and that there's no reason for a reasonable time to be any longer than is necessary to declare the company's intention. And that's the real point, isn't it?
It is, and you put it far better than me. My point of referring to what has happened is why it's unsuitable to start looking at all of the excuses for why such and such happened or didn't happen. The focus is on the sheer period of time since incorporation and what needed to be done.
Is the discovery of that adoption is needed, in other words, discovery that the contract precedes incorporation, relevant or irrelevant to the calculation of a reasonable time?
We say that our primary position is that it's irrelevant. It's
entirely irrelevant. So supposing in this case they could demonstrate that the company had been told the week afterwards, would that have any bearing on the reasonableness of the time or not?
Well, if they knew about the mistake, then that would undercut any suggestion that the reasonable time should be longer because they didn't know about the mistake.
So knowledge, or even, I suppose, what ought to be knowledge, or discovery of the error can curtail the reasonable time but not extend it, is that it?
Well, our primary position is that it's not relevant, but if it was relevant, it could curtail it. I mean, we say to focus, I mean, if you look at this, the statute, what it's talking about is a reasonable period of time after incorporation. You know, as Lord Shumpson says, what needs to be done to adopt this? You just need to write a letter, pass a resolution. And it wasn't envisaging that it could be 10 years because, in fact, through no fault of anyone, it wasn't known that this needed to be adopted.
Well, the assumption made by the draftsman of Section 22 is that the person who actually effects the transaction and the company and the grantor are all engaged in the transaction. So it must, I think, have been assumed that the company, upon incorporation, would have some kind of relationship, however brief, with the, let's call him the promoter, in this case Paul. And on that assumption, it can't have been supposed that there would be a problem about discovering the problem, because Paul may not have known much about the law, but he certainly knew about all the facts to which the law falls to be applied.
Yes, my lord. And the final point we make in terms of reasonable time is just to, if you look at in this interesting parallel, there's a provision dealing with the International Business Companies Act, which has a very similar provision dealing with pre-incorporation contracts. And that doesn't say reasonable time. That gives a fixed period of 90 days. So, from the date of incorporation. So what you're talking about is a fairly short period of time after incorporation to make clear what it is what your position is in relation to events which took place pre-incorporation. So the final point that I want to address on this issue is what might be thought as something of a jewellery point, but it's suggested by the appellant that if its registration of the conveyances is held to have been too slow for Section 22 purposes, then that would give rise to a windfall for the respondent. Well, you'd be unsurprised to hear that's certainly not how the respondent sees things. It was the respondent to whom the relevant property was first conveyed, and therefore, if her entitlement is defeated on account of the appellant's earlier registration, that could be described as a windfall.
Well, she's no better off as a result of this windfall than if she'd woken up to the procedural requirements rather earlier and done what she was absolutely entitled to do, namely lodge it for registration forthwith.
Exactly, but if she loses out, that's just an effect of the system of registration. That's what happens where you have land registration. But it's no more or less arbitrary for the appellant to be the victim of a different statutory regime dealing with pre-incorporation contracts. So either way, one of the litigants might feel that they're a victim of the statutory provisions, but it's certainly not accepted that it's a fair characterisation to say that the respondent has had a windfall. And it's also not correct, as for the reasons we've discussed, to try and read across the amount of time that was taken by the respondent to register her conveyance so as to suggest that the appellant has acted within reasonable time.
And you could have a true windfall situation. Let's suppose there hadn't been the prior inconsistent conveyance to her. On that event, the windfall would have been, I suppose, in favour of the estate of Emmanuel,
Yes.
and indirectly the residuary legatees.
Yes, my lord. So we only say that it's irrelevant how long the respondent may have taken, whether it was 10 days, 10 years, whatever. The question of reasonable time for Section 22 is not dependent upon how long the respondent took.
But when all void contracts involve a windfall for somebody, or virtually all, so it may not be a very good reason for not treating them as void that somebody will suffer and others will gain correspondingly.
My lords, the only other submission was the further submission on Section 22. I've said a little bit about it in my written case. Essentially, we say there's no basis for suggesting that any benefits are held on trust. You know, the source of those benefits is the statutory provision, if it applies.
Well, if it was going to be held on trust, Paul would have to be the owner of the legal estate, holding it on trust for the company. But he procured it to be registered, not in his own name, but in that of the company.
Yes, but we make the earlier...
So that it's hard to see where trust comes into it. The company
exactly, but the
was either the legal owner or not the owner at all.
Is the effectiveness of a deed for the purpose of securing priority dependent upon the correct legal owner being identified in the registration application?
Well, in our submission, yes, because it's a bit difficult to register the legal owner pursuant, or the alleged legal owner pursuant to the conveyance, if the legal owner hasn't been correctly identified.
Well, I mean, the essence of a deeds registry is it identifies deeds.
Yes, but
That's why I asked. I mean, it may well be. I just don't know the deeds registration statute of the Bahamas well enough to know whether that is a condition of the validity of the registration. If it is, then if he registered it in the name of the company, whereas he was the legal owner, that may be the end of that point so far as the appellant is concerned. But I simply don't know.
I'm not able to help you, my lord. I know that it's registered as a conveyance, and we can see that from the front page.
Yes, well, that's what a deeds registry is all about, but I just don't know whether that's a condition of its effectiveness. One could understand if it was.
So, my lord, unless I can be of any further assistance, those are our submissions.
The trust point was that Paul Rolle, as the person in whom statute vested the benefits of the conveyance, was, once the company was incorporated and he was the director of it, in a fiduciary relationship as the statutory owner, pursuant to Section 22.
The owner of what? What is the raise that he owns?
Owner of the plots conveyed to him, because the conveyance, if Section 22 applies.
Well, the trouble is, this is where you get into potential problems about the difference between a contract and a transfer of title.
A transfer of title must be under seal, must be by deed, and this contract has a seal, it has a deed. It is a deed. So we are in no difficulties about the conveyance of the transfer of title to Paul Rolle by the statute operating. None at all.
I mean, you just say that the receipt of title under this particular type of contract is a benefit under the contract, presumably under Section 22.
Absolutely. It's the benefit.
There are lots of contracts which
paradigm benefit.
Which aren't deeds and which in fact confer property rights on contracting parties.
Exactly.
So he becomes a trustee for the company when?
As soon as the company is incorporated.
But you see, the whole purpose of Section 22, he clearly can't be a trustee for the company before the company is incorporated. that I follow.
Yes.
But after incorporation, the scheme of Section 22(2) is that the company has an option, doesn't it?
Yes.
It either substitutes itself for him or it doesn't.
Yes.
If it does, it doesn't become a beneficial owner. It becomes the legal owner,
Yes.
the freehold owner. And if it doesn't,
Yes.
it doesn't become either
Yes.
a legal owner or a beneficial
Yes.
owner. There's no room, is there, for a midway trusteeship?
Because he is the director of the company.
Yes.
And he cannot himself act in a way which prejudices the company or would be in breach of his fiduciary duty to the company.
Yes,
It's the
I've seen
company's opportunity to adopt. So if he knew about it, he would have adopted. We say he did adopt. We say adopted within a reasonable time. But what he couldn't do was keep it for himself, because he owed a fiduciary duty to the company.
No, but that doesn't answer Lord Hughes's point, because you're relying on subsection 1 of the statutory scheme of section 22 to give him his interest, but and thereby create a trust. But subsection 2 is contrary to the existence of the trust, because if you're right, the company already had the beneficial interest, and therefore it had no choice as to whether to adopt. It was the property of the company. So this involves approbate and reprobate of the statutory scheme.
Well, the company was had the beneficial right to it, yes, but vis-à-vis the counterparty couldn't sue the company because the company only had a beneficial right, not a legal right. The promoter himself was the person who was personally liable and personally entitled to enforce the benefits of it in the same way that the trustee would be. So
this is relying not on the fact that he entered into the company on behalf of a non-existent, the contract part of a non-existent company, but on the fact that when it did come to existence, he was a director and had a separate
He was a director.
Duty as a director.
Exactly. Director and director of a company which had the statutory right to adopt.
It deprives it, doesn't it, of its option not to adopt?
Yeah.
The company itself could say it did not want to adopt. It's got a choice, the company, but the company director cannot himself take that option away from the company without the company having authorised.
Well, the company with knowledge could allow the director to keep the benefit.
Yes, absolutely right. And if he was also the sole shareholder of the company, then it would be a rather technical issue. But it seemed that he and his father were the shareholders of the company, so it's not perhaps purely technical. To be frank, I'm a bit more excited by Lord Briggs's point about the registration of the deeds, but that's not a point that seems to be open to me to take now. But is
well, it's not a point in your favour if it is a condition for a valid registration. I think you're in some difficulty standing.
No, you're absolutely right.
You're
No, that's absolutely right.
And brass and saying it's not.
That's absolutely right. But
nobody here has looked at the relevant provision.
But it might be in Paul Rolle's favour if by registering the deed he'd thereby got the title into.
If that was an effective registration,
yes.
Yes.
Yes, but that's there we are.
But he's not here as a party.
No, he's not. Absolutely right. Absolutely right. There were a number of points I wanted to come back on what Milena Friend said. He makes much of the suggestion that I'm trying to breathe life into ineffective conveyances, but I see that's begging the question as to whether they are effective or not, because in the case of the escrow, it's an effective escrow. In the case of the statute's operation, it's an effect. The statute itself gives it effect. So I cannot breathe life into something which is ineffective, but the escrow and the statutory provisions apply from the outset. In relation to the escrow, I repeat the submission I made earlier, that because it does not operate to convey anything to the grantee when it is executed as an escrow, the fact that the grantee is not in existence is not something which invalidates the escrow. The grantor has chosen to grant to a company which is to be formed. He cannot complain if the result of that is that he, at least in theory, cannot resolve from that escrow for the anticipated period when the company is itself formed.
To whom does he owe that obligation?
Well, he owes it to the unformed company. It's an obligation which can't be enforced. There's nobody there to enforce it.
Yeah.
But I thought obligations had to have counterparties.
To nobody.
Well, when that person then comes into being, he says, you broke the obligation you undertook in your deed, and it has an effect, and that is something which I can now...
Well, you can be a trustee for an unborn, but I'm just struggling with the notion that you can have an escrow where the beneficiary is an unborn.
You have what I say about that. The whole concept of an escrow is that it is not actually passing what that deed is intended to pass. The grantor himself has chosen to do that, and you can't be surprised if it does take effect on the very condition which he intends it to take effect. The suggestion was made that there was a pre-existing oral contract in this case prior to the conveyances. Our submission is that there was not. The company was not in existence. It was not there to make an oral contract. Only written contracts are affected by Section 22 in the Bahamas jurisdiction. Reasonable time to adopt. interesting in a way that the International Companies Act, which has chosen to give clarity rather than a flexible period, gives 90 days, perhaps longer than one might have expected to see. In my submission, with this particular asset, and given the ignorance of the parties, with this particular asset, why is there any obvious reason to take a step immediately? And what does it matter if no immediate step is taken? The adoption occurred within the first year accounting period. So the first year's accounts of the company, if anybody's looking to find out how strong the company is, the first year's accounts will show that it has been adopted. The likelihood is that if anybody had asked the company or any officer of the company, do you own that land? It said yes. If they'd gone down to the Register of Deeds, they'd find it didn't show that. But that's neither here nor there, because they seem to be rather slow in their registration in the Bahamas. And of course, also it's significant that it was suggested that that Emmanuel or his estate came back into play if there was no adoption by the company, but that's not correct. It remains in Paul Waller's hands. It's just that because when he registered it in the company's name rather than his own name, it's that we're here at all. Unless I can help you or hinder you any further.
Thank you. Well, the board is extremely grateful for the succinct and interesting submissions of both parties and the draftsman of the documents which they are based on. It will take time to consider what advice they will humbly tender to Her Majesty.